welcome to the second instalment of Outer-Temple Travel Talks, focusing on limitation in the Czech Republic, Denmark and Poland. I'm pleased once again to be joined by Klára, Kira and Gabriela. And we're going to look in this episode on further issues to do with limitation. And the first issue I'd like to talk about is extension of limitation. And the last episode, we learned that the general limitation period is 3 years in your country. Is it possible to extend that period at all through agreement between the parties or by seeking a court order? Klára.
Thank you, Jan. Yes, in the Czech Republic it is possible. If the parties are negotiating about the damages and about the liability, then they can make an agreement and they can suspend the limitation period for the time of the negotiations. If one party refuses to continue the negotiations, then the limitation period shall continue again. But the limitation period will never end earlier than 6 months after the refusal of the negotiations.
Okay, so that gives the parties negotiating a little bit of protection, that they don't have to issue proceedings straight away. Gabriela, is there a similar mechanism in Poland?
Yes, one of the ways you can interrupt the limitation period is by filing a motion for a summons to a conciliation hearing. That can only be filed once. Another thing we do very rarely is that we enter into a contract with the other party, and it's usually in cases concerning medical devices such as hip implants, where the case analysis conducted by the manufacturer can take up to 2 years. So it's in the interest of both parties to extend that limit. And the way it works is that the other party declares that they will not plead a defense of a lapse of the period of limitation later in court. But it's not governed by the civil code, or the court does not get involved in this.
And Kira, what's going on in Denmark?
It's the same as Klára described. So if you can agree that the limitation period is suspended, you can agree between the parties, but it can also lie in itself in the negotiations. So if the counterpart still hasn't abruptly refused any claim, you're still negotiating the claim, and then the limitation period will not start until, well, it's 3 years always, but if you negotiate and you negotiate after the 3-year limitation period has expended, you get another year from the time from where the parties agree that they cannot agree any longer. Then you get 1 year after that.
Okay. We're now going to move on to the issue where limitation is missed. So we're looking at a scenario whereby perhaps a client has come to you after the 3-year limitation period in your country. It doesn't fall within one of the obvious exceptions. Is there any way that you can ask the court to extend those limitations due to special circumstances and the like? Klára, what would happen in Czech Republic?
In Czech Republic, it would be a sad story. No way to go around. In this case, the only solution is to ask the contraparty for the acknowledgement of debt, if she's or he or she or it is willing to do it. And the acknowledgement of debt means that the party would have to stipulate that there is damage, that there is liability, and also stipulate the specific amount of damages which he or she is willing to pay. Otherwise, there is no way, for example, to ask the court to go around the limitation period. There are some special rules, which of course lawyers should know, which sometimes you should consider even if you already passed 3 years. One of the rules might be applicable now after pandemic times, because it says that the limitation period also doesn't run or is suspended somehow during the times of this major, so to say. So if you couldn't make a claim because of some this major event, this is something to consider and consult with a lawyer. Or if you couldn't make a claim because of some misleading communication or misleading acts of the defendant, then it is also something to be consulted with a lawyer, because there is still a chance.
So unless there's an extraordinary circumstance going on, or there's some element of deceit on the part of the defendant, there's no judicial discretion to extend limitation.
No.
Is there any
It's again just an exception from the rule, exception for the suspension of the rule. So court really can't suspend the limitation period.
Is there any discretion in Denmark, Klára?
No, sorry, it's also a sad story. If the limitation period has extended, it's like the claim has simply dropped. There is no claim. The courts cannot do anything. The only thing you can do is go to the counterpart and ask them if they are gonna claim limitation, or if they're gonna accept to have the court tried anyway, the court case tried anyway. In some issues, they say, well, the counterpart might be interested in a court ruling anyhow, because it's a matter of principle of general interest. They might say, okay, it might be the limitation period might be over, but we are still interested in having a court ruling, so we're not gonna claim a limitation. So that's the only chance you have.
Okay, so you're quite mean bunches in Denmark and the Czech Republic. Are you any more generous in Poland?
Well, I mean, there is a way you can try to still pursue your claim, because the Polish court cannot ex officio dismiss a claim solely on that basis of it being time barred. So this is a defense that has to be raised by the defendant. So you can either try your luck and hope that the defendant does not know that the claim has become time barred, or if they do raise that defense, you can try to prove to the court that dismissing the claim on the basis of it being time barred is contradictory to the principles of community life, as it is worded in the Civil Code.
So there's a little bit more judicial discretion in Poland, it would seem, even if the defense is raised.
Yes, but first and foremost, the matter of limitation in tort cases is always connected with a certain degree of risk, and it rests upon several discretionary judgment calls. However, we did have one case where this has worked for us, when there was a medical negligence that occurred, and our client has suffered from severe depression for 4 or 5 years after the medical error. So she really could not have sought legal advice, and this has been agreed upon with the court.
I think the message is that if you have a case where Danish, Czech or Polish law applies, it's 3 years, and start court proceedings and make sure that you stop the clock within 3 years. Now, there's been some interesting issue in the English courts recently with regards to what steps need to be taken to start proceedings within the limitation period. It's a case of Pandia, which may well be going to appeal. And it's now become even more important for English lawyers to understand what steps need to be taken in each country's law to actually start proceedings in time. Now, and one of the questions I'd like to ask you is it simply lodging the appropriate papers with the court, or does the defendant need to be served with those papers as well? Klára, what's the position in Denmark?
Well, you need to make a subpoena and bring it to the court to stop limitation. And you also need to send a copy to the defendant, but that's not in order to stop the limitation period, you might say. It's just code of conduct that you always need to send a copy of a subpoena to the defendant. So it's nothing to do with limitation, but you need to do a subpoena and send it to the courts.
So what the court documents complied with within the limitation period, that should be okay.
Yeah.
What about Poland, Gabriela?
Oh, it's pretty straightforward here too. You file a complaint with the court, and this is equal to the proceedings being issued and served. And the court is, in all cases, the only entity that may serve the proceedings on the defendant.
But it's filing the document with the court to start off with, which will mean that the proceedings have been started in time.
Yes, and hopefully your claim is perfectly done, and there are no formal things to be. If there are some mistakes in the claim, then unfortunately you cannot file it again in time.
Okay, so you need to be accurate. And Klára, what about in the Czech Republic?
Well, in Czech, the important thing is also to file it with the court. We don't have to be that formal, so there is no special form which we have to use. The only thing which has to be in the claim is basically who wants what, from whom, and based on what. If this is there, then you're fine, even though, of course, the court might send you a letter that you want to specify this and that. But if you say who wants what, from whom, and what, and under what, then basically you are within the period and it's there. And no matter whether you wrote it on a toilet paper or a very nice lawyer's papers. And so this is what has to be done with the court, and we don't have to serve it to the defendant, or we usually do before, but this is not obligatory for the running of the limitation period. Serving of documents to the defendant is important for another reason, which is nearly as important as the limitation period for us lawyers, because if you do not serve the documents to the lawyer at least 7 days before the lawsuit is filed, then even if you win the case, you will not receive the compensation of the legal costs.
Which of course is important.
Or the court can decide that you will not receive.
Absolutely. Well, that's wrapped up the main questions I had for you, but do you have, Klára, any other tips or tricks that you think maybe English lawyers should know about when dealing with limitation under Czech law, or just useful things that you think English lawyers should know about Czech law based on your experience?
Well, I think my advice would be more practical. It's not so much about Czech law as about communication, because my experience with dealing with cross-border cases is that the communication usually takes much longer than with national cases. And under Czech law, we usually have to give to the court lots of information about the damages, about the injured parties, about their feelings in order to calculate the damages, and so on and so on. And very often it's a big, long homework for the injured party. And my experience is that it really takes time to have this homework done, because you are communicating with the English lawyer is communicating with the victim, with the injured, so it takes time. And so just bear it in mind when you are sending us cases from the UK.
Gabriela, do you find sometimes it's easier just to get on the phone rather than just exchange lots of emails in these kind of cases?
Well, it depends if the other party does answer the phone, because sometimes it's not the case. Well, I mean, I've only had really good experiences with communicating via email with British firms. Although I think you really have to realize that the limitation periods here in Poland are very strict, and there's no way to extend it, really. Insurance companies will not agree to enter into a contract with you and extend that time. So only very rarely, as I said, in medical device cases, and not always. What you might find helpful, though, is that you can also file a claim with the insurer or report the accident to insurer, and that will also interrupt the limitation period.
Thank you. And Kira, do you have any tips on dealing with limitation, or just when we've been working with British law firms?
Well, the same as already been said. You can either write or you can call. It depends on the case. But also, like Gabrielle says, you can also in Denmark, if you make a report to the insurer, you actually make a report of the claim to the insurer. It will also stop the limitation period, and that you will be given a year after the insurer has gone back to you and told them how they see the case. So you actually you buy yourself some time if you just report the claim to the insurer as soon as possible. So especially in traffic accidents. So that's definitely a tip.
And I think that just goes to show how important it is that we cooperate and we do communicate. And I think that we get you involved in the cases as early as we can, so we're aware of those risks when it comes to limitation, and we're aware of those little devices that might exist to buy ourselves a little more time. Well, that brings us to an end for today. Thank you very much once again, Klára, Kira, and Gabriela, all of which are members of POPL, and links to their profiles and their websites will be found on the link to this vlog. Thank you very much.
Thank you.